Both parties are present in the virtual courtroom along with their respective attorneys, Mr. Hess on behalf of the plaintiff, Ms. Gillum on behalf of the defendant. We are here on the defendant's motion for a temporary child custody order pending a hearing. I will indicate that the court has read both the motion and the response, including the attachments, with the exception of the hearsay that was attached. Spent actually quite a bit of time reviewing the Florida transcript. So with all of that, you don't have to repeat everything you have in your motion or response. And Ms. Gillum.
Yes, Your Honor. As this court is aware, I'm sure that, you know, these parties have a 9-year-old and an almost 8-year-old kid. And since the court issued its opinion on 10/22/2024, and in the time period between the de novo hearing and the release of its opinion, there has been many things that have occurred that are relevant to the best interest factors in this case. And there is proper cause, if not a change of circumstances, for this court to review custody and parenting time. As you've read in my motion, there have been issues where plaintiff has prevented the children from having any contact whatsoever with their mom. She's gone 65 days at a time with not hearing from her kids. I know she's mentioned filing complaints with the front of the court. Unfortunately, I think there are some things that were in the front of the court recommendation in order that didn't quite make it into the court's opinion in order. And so there were some issues regarding whether or not her court-ordered video calls were still an actual court order. Despite that, having no contact for 65 days whatsoever is not reasonable and not in these kids' best interest. So we have that. We have the children, when they actually are able to contact mom, they're telling her that they're being left alone, that they're afraid, that they're not eating. She's had to send them, she's had to use DoorDash to send them food because they're telling her that they're hungry and they're not able to eat anything and no one's there to feed them. So she's done that a multitude of times. The children are reporting that plaintiff and her boyfriend are screaming and yelling and fighting all the time, and that they're doing that while they're trying to sleep, and so they're not able to sleep sometimes. The children are reporting that Lucas, the plaintiff's boyfriend, is hitting them.
I'm going to stop you. Mr. Hess hasn't objected, but I'm going to stop you because the court does not permit quoting the children like you are.
Okay. Well, I'm just telling you,
So.
they're reporting all of these things. They're reporting, and
I've read the motion.
And the court's read the transcript regarding the court hearing, so they know that the kids are actually testifying about being abused by plaintiff's boyfriend. So they're having these issues. We've had police and CPS contacts multiple times in this case, and there are open CPS investigations as of right now. So there's an incident that just occurred in March, which I think was the final nail in the coffin here. Why my client filed this motion, and it's because, you know, when a kid gets so hard they have a busted nose and bruises on their cheek, that is not any type of parental discipline that's appropriate in this case. So there are open investigations. My client has tried to get additional records regarding those open investigations. Unfortunately, because they are open, they're not able to submit those records at this point, so we're still waiting on those. There are teachers that are reporting that there are behavioral issues. I know the court indicated that it didn't read the letters that were submitted by the teachers. But there are those issues. There are issues regarding attendance. These kids have missed about 12 days of school. That doesn't include all the tardies and the times that they left early. There are problems with communication. Not only is she barring communication from the kids, she's also not communicating whatsoever with this plaintiff mother. So she's ignoring her phone calls and her messages. And I know that at one point there was a court order for our family wizard and the referee recommendation in order. However, again, that did not make it to the court's opinion in order that was issued in October. And so I guess the plaintiff feels like she doesn't have to communicate at this point. There's issues regarding her refusing, and when I say her, I mean the plaintiff, refusing to sign releases that allow the defendant access to the kids' medical records in Florida. So she went there, tried to get copies of medical records.
I'm going to object to that. That's nowhere in the motion that was filed. There's been some different things mentioned here this morning that were not in her motion. I've not had a chance to review any of these allegations, the new stuff that's not in the motion with my client.
Right.
Well, and that might be the case. And if the court wants us to file an amended motion, we can do that and add all this stuff in there, or we can appropriately address this at an evidentiary hearing. But that being said, there are obviously Ms. Jones did not have the benefit of our counsel when she filed this motion. So there are some things that we've discovered since then. So if the court does want us to file an amended motion, we can definitely do that. There are other things obviously regarding, plaintiff drinking, plaintiff giving the kids medication that aren't theirs,
Again, I read your
Ms.
motion.
Jones,
That was
right.
in there. You don't need to repeat
Okay.
all of that.
Well, that being said, Judge, the defendant is justifiably concerned about the well-being and the safety of these children. So at this point, the burden of proof to establish proper cause and change of circumstances is simply a preponderance of the evidence, Judge. And I think we definitely have enough here to meet that burden. The defendant is requesting that this court schedule an evidentiary hearing. And we're also requesting that the children be placed in her care and custody pending that evidentiary hearing. And we're asking that the parties be allowed to make phone calls because, again, what was ordered in the referee recommendation order didn't quite make it to the opinion and order. So now there aren't any court-ordered phone calls that are enforceable at this point. So we're asking for twice weekly phone calls with the children for at least 30 minutes. We're asking that those phone calls not be monitored with by plaintiff or interfered with either party. We're asking that the plaintiff's boyfriend not have any contact with these minor children, considering the abuse and neglect allegations that are pending. And we're asking that plaintiff's parenting time either be supervised or suspended until the evidentiary hearing.
Mr. Hess.
Your Honor, this case has been one of the most closely scrutinized cases that one could ever imagine over the past 3 years. Not only has this case been under the scrutiny of the court, the constant motions, the court, the friend of the court has looked at this. There was a 5-day trial. CPS in Michigan was involved in various allegations, nothing substantiated. There's the CPS agency in Florida has had 5 complaints since my client moved there last spring. Nothing has been substantiated. This is the court issued its opinion after 5 days of trial. There's no basis to change anything. Vadvarka certainly has not been met. The defendant is recording the children on phone calls, trying to dramatize any little thing that she can, trying to work up the kids. It's really not healthy for the kids to be so constantly in litigation. The defendant attempted to get a restraining order against my client's live-in boyfriend on behalf of the children in Florida. I mean, that was denied. There's just no basis to conclude that there's anything here at all. There's no excessive drinking around the kids. There's no abuse of the kids. There's been allegations, but nothing substantiated. There's no criminal charges against Mr. Mello. I mean, this is just frivolous. I mean, and how often is my client, going to have to deal with this? The defendant is extremely litigious. We get that. She appealed your decision. We're waiting for a decision from the appellate court on that. But Your Honor put a ton of time into this. Your Honor made a very thoughtful opinion. That is the order of the court. My client follows the order of the court. There's no show cause. There's nothing to indicate that my client has not followed the order of the court. The phone calls were not ordered. My client follows the orders for what did. Should my client, she's being criticized for not going out of her way to do extra stuff for defendant. That's perfectly understandable. And that doesn't give rise to shade or Vadvarka. Again, I mean, she's recording the kids, trying to work them up and dramatize anything she can. There's just no basis here. I think her motion is frivolous under MCR 2.625. I mean, this is outrageously expensive for my client to deal with. She has a perfectly good family unit in Florida. The kids are well cared for. CPS has looked at this case up and down. They haven't substantiated anything. I mean, there's no basis to do this. I do think some attorney fees should be awarded at this point. You know, I would ask for at least $1,000 for this, for having to go over these allegations with my client.
And the court will issue an order for our family wizard. That was an oversight on my part, because I think clearly in this case, that's how the parties should be communicating so that there's a record. As far as telephone parenting time, I also think that's appropriate. Ms. Gillum asked for 2 times a week. Mr. Huss, is that amenable to your client?
No, I think that should be, you know, I think it should be fairly limited. Again, I mean, she has quite a history of, I mean, these just becomes, you know, investigative questioning. I mean, I mean, there was, so I would say as minimal as possible. It really puts my client and the kids in a bad spot. You know, the kids are being recorded. I don't think that's appropriate at all. I don't think there should be any recording going on by Miss Jada Jones.
All right, well, what I'll do on that issue is I will send it to the front of the court for them to make a recommendation on the limited issue of telephone parenting time or Zoom parenting time or virtual parenting time, whatever you want to call it, because we can't get to the bottom of that today. But in the meantime, I will enter an order regarding our family wizard.
And Your Honor, I mean, it seems like this court is based in its opinion in part upon the fact that some of these CPS cases haven't been substantiated. What about the fact that they're still open CPS cases?
Well, if they are substantiated, the court, you can file another motion, but
so is the
I'm
court
not gonna
saying
address
that
that today.
only if they're substantiated that's going to be proper cause
What
to
I'm
change the
saying
circumstances?
what I'm saying is the history of this case shows that Ms. Jones is very litigious. Also, has put forth many arguments to this court and allegations to this court that were not based on substance. And at this point, it is not ripe.
Well, so here's the thing, Your Honor talks about a lot of this being hearsay, but the problem is until we can actually have an evidentiary hearing and call these people to testify about many of the things that are being alleged, how do we prove that to the court? Please don't
argue with me. Please don't argue with me. I've made
I'm just
my
asking
ruling.
for clarification, Your Honor.
I'm finding no proper cause or change in circumstances, so we don't even get to an evidentiary hearing at this point. All right.
Understood.
Thank you.
Thank you, Your Honor.